So, I am the holder in due course. I am here as a third-party intervener, making a special appearance as an authorized representative for the defendant. I accept for value and return for value all the charging instruments in this matter, and I make my exemption as principal available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts contained in the charging instrument. Please use my exemption for offset and adjustment of the public charges against the defendant and release the order of the court to me immediately. Hello, people. It's Doug from Salt Lake. So what I just read is what you are supposed to say in the courtroom. And I didn't know that. And whether you are fighting a validation of debt letter, debt collector, or you're fighting child support, or an Office of State Debt Collection, or, it doesn't really matter. I am the holder in due course. Are you the holder in due course? And what is the holder in due course? And what is the holder? And what is a negotiable instrument? And what is a third-party intervener? And when you walk into that courtroom, man, who's the defendant? We've gone over this before. You are not the defendant. That is a legal fiction. That is an all-capitalized name. That is a transmitting utility. You are not the defendant. So I wanted to start this little video today with that. That is something that I got from high frequency radio and use of L and understanding contract law and you win, and from Old Dog New Tricks and a couple other places, and I kind of put it together, and it is basically disconnecting the private from the public, because in that statement it makes very clear that the defendant is in the public and has public charges, and that you are using your exemption as principal, which is you in the private, okay, because you are the one that backs up the full faith and credit of the United States, which is bankrupt. Full faith and credit is in HJR 192. That says that all of us have been pledged, all of our credit and all of our labor and energy has been pledged to the Federal Reserve to back up this bankrupt corporation known as the federal government. And the IRS is the accounting agency that oversees all of that, and they work out of the Department of Treasury, and Steve Mnuchin is the holder of my bond that I sent him, and I am the holder in due course. So I hope some of that makes sense. If it doesn't, we've got other videos on that stuff. So today I want to talk about the Maxims of Law, because this is kind of crazy, I know, but I was going over the Maxims again because I am 8 days from filing my lawsuit, and I'm excited. And I know that sounds a little weird, but I can't wait to get this thing going. So I went to the pro se litigants thing here for the United States District Court for the District of Utah, and they have this little form that you can fill out. And I was reading through it and kind of just checking some things off, and it's really amazing. So for instance, this one here has $75,000, okay, and when you start looking at the actual complaint that you fill out for a civil case, okay, you get this right off their website. The pleading um, and all of the complaints and the charges and the cause of action and the amount in controversy and the statements and the relief requested, um, everything that is in this 12-page document, 7-page document. What is it? It's 5-page document. Everything that's in this 5-page document is in our bill in equity, and I cannot wait. Obviously, I want no for a trial by jury, because what I'm doing is an administrative process, and I'm just going in for summary judgment. So anyway, I think that's kind of weird, man. On the, let's see, what is it? So I'm looking at the calendar right now. So I should get my certificate of non-response on the 16th, which will give me the weekend, 17th and 18th. And then on the 19th of August, we are going to go down to the district courthouse and make sure I don't have my knife in my pocket or anything metal on me, and go in and file my administrative process. And we're going to get certified copies of everything. And one of the other things that they tell you in there is to make 2 copies, and you got to fill out a cover sheet. So this is, this is stuff that we need to look at. And so anyway, let's get back to the Maxims of Law. Because when you look at what you're dealing with when you go to federal court, and you're filling out affidavits, and you've got memorandums of laws and judicial notices and all this other stuff, you got to know that when you're in a federal court, you actually have rights in there. Okay, they deal with this is not an administrative process. Okay, this is this is not an administrative agency. Okay, federal court is a lot different, and I've gone through some other stuff that I'll show you later. But they have a little guidebook and stuff that tells you what to do, and how to service process people, and which we already know. You do affidavits of service, certificates of service for everything you do, and you get a third party, and that's where the notary comes in, because she is considered the custodian of record, and everything is foolproof, and I'm not going in there with anything but a loaded, just loaded for bear. So actually, I'm excited, but I wanted to look over some of the maxims of law, and just to kind of confirm that I'm doing the right thing. So number 1 here is a workman is worthy of his hire. The first of these is expressed in, and then they give a bunch of Bible quotes, because whether you believe in God or not, I do. Jesus Christ forgave me and everything that I did, and I am a free man. And it is against equity for free men not to have the free disposal of their own property. Well, if I work for it, man, then that should be mine, right? If I put my labor into it, then it should be mine. And all these administrative agencies are set up to take your energy, take your essence, and use it for their own, commercial gain. And I'm not doing it anymore. So, second maxim is equality before the law, right? No one's above the law. Everybody's equal under the law. Okay. So, and then 3 here, this is one of the most comforting maxims. And your foundation, if you have a peace of mind, your security, and your capacity to win and triumph. So in commerce, truth is sovereign. So if you go in there and tell the truth, hey, this is what I did, or hey, I'm not in contract with these people, or hey, listen, my kids have never been on welfare, and I don't qualify for child support, and I've been taking care of my kids for 10 years, and there's no reason for the court to intervene, and you guys are trespassing, and you need to back the F out. Put it in an affidavit, see what happens. Okay? So truth is sovereign, always, right? Truth is sovereign, and the sovereign always tells the truth. Your word is your bond. Okay? That's where your affidavit comes in. It's where to tell the truth, whole truth, nothing but the truth, so help me God. No basis for law and order, no basis for accountability. There will be no standards, no capacity to resolve anything if your word wasn't your bond. So truth is expressed in the form of an affidavit. So, if you're drawing up paperwork and stuff, please look into getting, an affidavit of Walker Todd, or any of the numerous affidavits that are out there. I have a few, and that is your solemn expression of truth. In commerce, an affidavit must be accompanied and must underlay and form the foundation for any commercial transaction whatsoever. Well, does anybody ever get an affidavit from any of these state and county and city and, no, you don't, because they're not going to. They're not going to put their name on it, because they will not swear to anything, because they know it's all color of law. So we've been over that too. So number 5 is an unrebutted affidavit stands as truth. So basically, and we're going to get to it down here, how you need to bring it up. If you don't bring up your rights, then you have none. But if you put in an affidavit and they don't say anything about it, okay, and they don't hit it point for point, he who does not deny admits. Okay, so, and we've been over that several times. I always stick at the bottom of my paperwork that if you are silent and you don't respond, then that is your agreement to the terms of this contract. Okay, so if they can do it, you can do it, right? In commerce, for any matter to be resolved, it must be expressed. In other words, man, you got to say something. He who fails to assert his rights has none, right? So if you don't bring it up, hey, Your Honor, excuse me, I have that affidavit, and that's basically the judgment, because he didn't rebut my affidavit, so that stands as truth. And then let them haggle and argue about that. So he who leaves the battlefield first loses by default, right? And this is why I'm still on here, and this is why I'm still appreciative to my subscribers and people that comment, because I will not give up, okay? I don't care. You can put me in jail. I've been in prison in 2 states. I'm not afraid to go to jail, okay? I got a great girlfriend. I got a great life, and I want you people to get the hell out of my life and leave me alone, okay? And sacrifice is the measure of credibility. No willing to sacrifice, no liability, responsibility, authority, or measure of conviction. In other words, nothing ventured, nothing gained. So hopefully the people that are watching this video are not one of these people out there that's going to email me and say, hey man, can I get those documents for free? Because if you're not willing to work for it, if you're not willing to do some work, if you're not willing to look up a couple of words in the dictionary and read and read and read, and trying to internalize some of this stuff and wrap your head around, documents, documents are out there, there's all kinds of information. And, I'm actually going to a university, SBC University right now, and I have successfully completed my creditors and their bonds, and I'm doing some other stuff because I want to understand what the hell is going on, dude. I want to be able to go into this courtroom and rebut all of their presumptions, okay? And I want to tax these people, man, okay? I want to be able to go in there and get this stuff vacated, and I want them to leave me alone, okay? I want on the do not detain list, okay? I'm not in their jurisdiction anymore, and we've been over this before. They're not going to give up easily, okay? So I have to fight. Number 10, satisfaction of a lien. How do you get rid of a lien? A lien or claim can be satisfied only through rebuttable affidavit, point by point, which they never do, resolution by a jury, which they'll never do because they don't do juries in at administrative procedure, because they know you bury them with a jury, or payment. And what they're basically doing is they're making you pay, okay? Because all this other stuff, affidavits, they're not going to do, jury, they're not going to do, okay? Because it's all non-judicial, and they don't want anything to do with a jury. So No court, no judge can overturn or disregard or abrogate somebody's affidavit of truth. The only one who has any conviction or capacity or right or responsibility or knowledge to rebut your affidavit is the one who is adversely affected by it. In other words, the state of Utah, the state of Missouri, state of New York, they cannot fill out an affidavit, right? No one else can know your truth. This is your job, okay? You've got to speak up for yourself. You've got to know the maxims, okay? If you fill out an affidavit and they don't rebut it, it is truth, and you must bring it up in court.